everyone. Today we have our meeting on technology transfer for European SMEs in China, and now we're going to start. I am the advocacy and working group coordinator of the EU SME Center, and I'm going to make a brief introduction of the center. The EU SME Center is an EU initiative that provides a comprehensive range of hands-on support services to European SMEs, getting them to do ready to do business in China. And our team of experts provide advice and support in 4 areas: business development, law, standards, and conformity, and human resources. Collaborating with external experts worldwide, our center converts valuable knowledge and experience into practical business tools and services easily accessible online. I'm going to talk a little bit about the context of this meeting. It's going to be on technology of transfer of technology. Transfer of technology is defined as the movement of knowledge, skills, know-how, and other valuable assets from one for-profit organization to another. Has been a common practice for foreign companies operating in China for years. And when carried out properly, technology transfer has allowed foreign businesses to successfully gain market access in China. However, technology transfer in China is not without risk, and companies have faced situations where they have seen their technology stolen through leakage of IP due to their Chinese counterparts breaching their agreements or Chinese law. In spite of attempts by Chinese authorities to ban forced transfers of technology in pieces of legislation like the foreign investment law, but according to the European Chamber's Business Confidence Survey 2021, 16% of respondents reported being forced to transfer technology. Given the risks of loss of competitiveness and market share associated with technology transfer processes, it is essential for European SMEs, European companies, and in particular SMEs to think carefully about to guard against IP risk when transferring technology to China. Today, the European Chamber, the IP SME Help Desk, and the EU SME Center are pleased to host this working meeting. And we have Helika, the project manager of China IP SME Help Desk, who will introduce briefly the help desk and the work the help desk is now carrying out. And we have Matthias, IP business advisor, who will give a 30-minute presentation on the newest technology transfer conditions, as well as the role of the various contracts in protecting IP. Helika, now I give the floor to you.
Thank you, Susanna. Could we maybe have a slideshow also up, and let's go to the slide where we have all of our services. I go for the presentation. Oh, there. Many of you already know the help desk quite well, but I will still briefly go through our services and what we do. So China IP SME Help Desk is a European Union funded project, and we assist European small and medium-sized enterprises with intellectual property rights issues when they internationalize their business, particularly China. So we offer a variety of services to SMEs, and you can see all of the services here on the slide. One of our core services being the inquiry helpline, which is basically an email address, and you can see the email address there on the slide underneath that big question mark. And if you email us via this email address, you can ask us any intellectual property rights related questions that you may have. and receive a reply within 3 working days. And it's really any intellectual property rights question you might have, and it doesn't have to stop there, that you simply ask us a question and then receive a reply. If there are any further issues, you're more than welcome.
No, it's fine.
Okay. You're more than. Are we online? We're off.
Yeah. He is just connecting.
We
I thought he was still online. He was
Still online.
still online.
Yeah.
Okay, sorry about that short confusion. We thought we were offline, but yeah, let me continue then from Inquiry Helpline. If you need further information, if you need further assistance, it is very easy to book a one-on-one consultation session with us. This is a fairly new service that we're providing. And again, you can have a 30 to even 1 hour discussion with our IP business advisor, Matthias Zubimendi, and he would be happy to answer all of the questions you have. You can explain your business and your business idea. You can explain your concerns, and Matthias will guide you through all the IP issues that you might have. Other services that we provide include the training workshops and webinars, such as what we're doing now with technology transfer issues. We organize those training sessions together with our partners, such as chambers of commerce, business associations, embassies. So if you are a business association or an embassy, please do reach out to us if you would like to also organize a training workshop like what we're doing today. Of course, from our website, and you can see the address of our website also underneath the website logo. From our website, you can get access to a variety of intellectual property related materials. The website really functions as a one-stop shop for all IP related materials about IP in China. You can get access to our library of guides and also fact sheets, as well as e-learning modules. And a variety of materials, including our blog, where we do issue all of the latest news concerning intellectual property rights in China. So please do check out our website where you can find information about IP, anything that you might need. And now I've already taken up quite a lot of time, so without any further delay, let's give floor to Matthias for the presentation.
Hi everyone. Okay, as it was introduced before, today the topic is technology transfer, how to get ready, how to prepare your company to, in any case, if you want to transfer technology or if you want to avoid seeing some of your technology being taken without your consent, and to control exactly what do you transfer, what do you provide, what are the terms and conditions, how to get ready. Wait, this is too fast. Here we go. But first, I will start with a brief introduction about intellectual property rights, what each one of them protects. As you can see in the screen, there are 6 types of IP. 5 of them you protect them by registration. In the case of invention patents, what you protect are going to be products and processes. By that I mean the technology, the new technology applied to product and processes. With utility models, which is a type of IP that EU companies may not be very familiar with because it doesn't exist in all the EU jurisdictions. It's a type of intellectual property right that also protects products, the functional aspect of a product. It shares the same requirements as invention patents. That's why some companies, when they are planning to do their IP protection strategy, they do a parallel and dual registration of invention patents and utility models. But utility models shouldn't be confused with design patents. Design patents, they also protect the shape of the aspect of the product, but the area of protection is different. Design patents, they only protect the aesthetic aspect. No functionality, no technology applied to the products. In the case of trademarks, what they do protect is all type of sign that you can use to distinguish your product from the one of your competitors. Your company name, your product name, your logo, that can be registered as a trademark. Copyrights, normally we associate them with art. However, for companies, we have to keep in mind that some products, for example, software, databases, they are protected by copyright. So it's something to take into consideration. And finally, the last type of IP is trade secret, which is not protected by registration. The secret keeps protected as long as it remains as a secret, but it's a type of IP that we will see later during the presentation, so I will not dedicate much more time. Let me see if I can. Here. There are three main principles regarding intellectual property rights that companies should keep in mind and should remember. These are very, very important. The first one is registration. You are not going to be protected in China if you are not registered. Again, trade secrets, they are not registered. The second one is the first to file rule, or the first to file principle that is associated with the registration, which means that the company or the individual that is the first one in filing the application will have a priority over any future registration. It doesn't matter if this first application is done in good or bad faith. It will have a priority, and the second one or the new applicant will have to take it down first. That's why it's very, very important to do the registration as soon as possible, even before entering the Chinese market or before starting interacting with any Chinese partner. Finally, the third principle is called territoriality, which means that the registration you have done in a country, it will only guarantee you protection within the territory of that country. In the case of China, we have to do one more explanation that the country has 4 different jurisdictions. You have mainland China, Hong Kong, Macau, and Taiwan. And each jurisdiction works independently. And if you want to be protected in each one of them, of these jurisdictions, you will have to do 4 different types of registrations. Said that, I will start with a brief introduction of technology transfer, which was already introduced by Susana in her presentation. Technology transfer is any transfer of knowledge that is done from one institution or company to another one. There are different ways in which technology can be transferred. Some of them are more intuitive, some of them are not so much. That's why companies should always keep in mind that they may be transferring technology even if they don't know they are doing it. The most classical examples of technology transfer are consultancy, where the company teach another one about how to do a process, how to do some service. The other company that one is receiving this knowledge may be learning, maybe improving, maybe even develop a new updated version. There are also another type of transfer, which is classic with the patents, which is patent licensing, in which the company just provide the license to another one. License normally are not given or granted only what is present or can be read in the license, but there are also some knowledge that is surrounding that patent, that is associated, that is necessary to take the patent into practice perfectly. And that is also a situation which companies have to take into consideration. Of course, when there are spin-off companies, when there are JVs, there are joint ventures, there are also most likely going to be situations of technology transfer. In general, we have to distinguish 3 types of technologies: emerging, innovative, and established. Emerging are the ones that they may be fruitful in the future or not, we don't know. They're just in the very early stage. Innovative are the ones that we know they're going to work and we know they're going to be profitable or game changing from the sector. And established technologies are the ones that they have been in the market for a quite long time and they're quite stable. Normally, companies should be more careful towards innovative technologies because are the ones that, yeah, most likely are going to be more interesting for your partners. When we talk about technology transfer in China, we have to know exactly what rules are what laws we have to analyze. The key one is the foreign investment law that came into effect 2020. They have some interesting rules in which one of them is the national treatment, in which foreigners should be treated as nationals when interacting with any type of when interacting with any Chinese authority. There shouldn't be any type of discrimination just for the fact of the nationality. They protect the investment. As Susana mentioned, that forced technology transfer shouldn't be forced. It's not allowed. We also have to take into account the regulation of the administration for import and export technologies. We will see it later. And the type of companies that we have to take into account, what companies some companies have restrictions towards what type of technology transfer and especially what type of technologies they can own or not. So the first advice or the first topic to take into account is to be careful with the bureaucracy. Your company should check the technology import and export catalog. These are rules regarding technology transfer that are coming or leaving the country, but that I mean by licenses. These technologies can be in three categories: free, importable, restricted, or prohibited. Those technologies that are freely importable, companies can just provide licenses freely. There's not going to be any type of issue. Prohibited is the opposite. You cannot transfer this type of technology. That's also very simple. Normally, this type of technologies are related with military aspects, and they're very, very specific. The problem are the restricted ones, because these catalogs, they are quite broad. The content is, let's say, in some way a little bit vague because it can cover many aspects. So companies should always be checking if the technology can fall under their prescriptions or not. And if you want to provide a license in one of these sectors, what you have to do is to ask for permission. The process is not extremely complex, but if you are providing this technology to a Chinese company, it should be the Chinese company the one that is requesting to the government the permission for importing or exporting the technology. It is them the ones that should start the request. Then we have to take into account the negative list for foreign investment. Negative list, they also distinguish three types of situations in which foreigner companies may own or not, may be able to own type of technology. Again, we have three different types of situations. We have the free to invest, in which foreign companies can invest and own technologies in that sector, which is the vast majority of technologies. We have the prohibited ones, in which foreign companies cannot own the technology. And the restricted ones are scenarios in which foreign companies can only own and invest on that type of technology under certain circumstances, which normally are different types of companies. Normally, in this restricted area, your company or a foreigner company will be able to invest in that technology if it's part of a joint venture in which a Chinese company has more than 50% of the ownership. So that's the regular and more normal restriction. Again, your company should check before investing, before entering any research and development agreement, if you can actually own this technology or not. Because the consequence of the consequence of falling under this scope and not realizing in advance means that you already invested, you're already there, the technology is developed, you're going to file the patent and you realize that you cannot own it because you're a foreigner, well, the entire property will fall under the scope of the Chinese company. So you want to avoid that as much as you can. This catalog, the same way with the foreigner export and import, the catalog of import and export restrictions, they are changing, not very often, but they are in constant change. They are updating the content at least once a year. So
Chinese.
it's a Chinese law.
Foreign law.
Yes, these are Chinese law. Yeah. So they are being updated quite regularly. So yeah, it's better before entering any type of research and development or any type of license or agreement, just to double check before proceeding. The following advice that I can give you before transferring technology is to study your partner. The problem for EU SMEs is how to do that. They don't know. It's a very common scenario that we see at the help desk, in which they say, okay, we have been contacted by this company, but we don't know anything about them. Can we trust them? Well, it's not an easy question. My first advice always is to first ask for the legal name of the company. It is a common scenario in which companies, they introduce themselves using an English name, which then when you look for it, it doesn't exist. What you need is a legal Chinese name. You need to know who they really are, how they are registered in China. So my first advice is always ask for the business license. Then you can take advantage of the National Enterprise Credit Information Publicity System, which is the link, you can see it in the screen, which is a database published by the Chinese government, in which you can see all of useful information. You can see who the legal representative is, what's the capital, the business type, business scope, sanctions, shareholders, etc., etc., etc. You can also ask information to chambers of commerce, embassies, public institutions, etc. If you don't know how to use the National Enterprise Credit System Policy System, you can check our guide in our website, or you can contact us and we will run the search for you and we will explain you what are the basic information. That's something that we can do at the help desk. What is important to highlight is that you should know who the legal representative is, because if you are entering into any type of agreement, then that agreement should be signed by that person in order to be enforceable against the company. You should also take into consideration what's the business type and scope they are registered for, because it has to be a match between what is mentioned there and the type of technology that you are trying to obtain, or the sector in which you are invested. Also, you can see if there is any sanction or who the shareholders are, in order to know more about the background and how reliable the company is or not. As I mentioned at the beginning of the presentation, I'm going to talk about trade secrets. By trade secret, I mean any type of information that your company knows, that is not known by your competitors, that gives you a competitive advantage, and you are keeping it as a secret by applying some protective measures. Since the secret belongs or it's kept protected as long as it remains as a secret, it means that you cannot do a registration, you cannot disclose it, you cannot make it clear. So when you try to enforce trade secrets, you are not using any specific IP law, but what you are using is those laws that protect against the unfair competition. And when you are claiming going to be a compensation for the damages you suffer, but you are not going to keep owning the technology. It will be available, technically speaking, for the ones that didn't do any unfair competition act. So maybe you can claim compensation against one competitor, but the other ones will be able to keep it to use it freely. So that's why it's important to, if you have a technology that you know is relevant, that is not still registered as a patent or you decided to not do the registration, then to use as many trade secret measures as possible. We can distinguish between three types of measures. Some of them are physical. It means that you make it clear that what you're trying to protect should remain as a secret. The most common example is that you use a stamp on your documents to let know the reader that this should be kept a secret. But if you have a prototype, you just have it in a room locked. All these type of physical measures, they should be used. There are also technology measures like blockchain, the use of encrypted communications that is very advisable in order to make more difficult to outsiders to have access to your server. Another common scenario is that the server that the company is using is only accessible for the employees in those areas or those folders that are of their interest, but not the entire server. And then what is clearly important is the contractual measures, the famous confidentiality agreements, NDAs or NNS agreement, non-disclosure agreement, in which when you are providing any or you're someone letting know information that is considered as a secret, that they're making them know that they should be confidential about this content, they shouldn't disclose it, and if they do so, that they will be they will have to pay compensations. The criteria of how many protective measures you should apply to keep the secret as a secret, there is no specific rule about that, but the criteria is that your measure should be reasonable. This means that if your technology is quite important for your business, for your sector, and is giving you a lot of profit, then you should invest a lot of money on protecting this secret. But those trade secrets that are rather secondary, they just an addition or a complement to a technology or a patent or a product, then it is acceptable that you don't apply so many protective measures. Again, there is no mathematical way of knowing which is the exact point, but you have to be reasonable. Let me see. Yes, contracts. It's very important when you are, if you're going to transfer, technology transfer, that you have good contracts. Before entering into license and joint venture contracts, I'm going to make I want to make something very clear for any type of contract that you have in China, and that is always have a contract in Chinese language. By that, I don't mean that is going to, you need only a Chinese language contract, but always have a copy in the Chinese language that is original, that it is signed for every single party. You can have it in your own language, you can have it in English, and any language that makes you feel comfortable. A common question that we receive, or a common comment that we receive at the help desk when I explain this, is that the company says, I don't want to sign a Chinese contract because I cannot read it, I don't know what I'm signing. That's true. That's why many companies, they prefer having the contract in their own language because they can read it, they know what they're saying. What I'm trying to explain with this is always have a version in Chinese and make it signed, make it original. And you can always, if you want, you can say that if there is any difference between both languages, that the one that will prevail is the English one or the international one. But having the Chinese language contract is very important because if there is any dispute and you will have to enforce it with the Chinese cards, if you present only a foreign language contract, you will be requested to present a Chinese language translation. And you will present one translation, but your counterparty will present another translation. And what happens if they don't match? Well, if they don't match, you enter into a new discussion about who's right about the translation. That is going to cause a delay on the case for at least 6 months. So this can happen many times, and you can end up facing a very, very long dispute. Said that, when we talk about joint ventures, you have to make clear also, or the topics that you can see in the screen are the ones that they have to be clear and they mandatory have to be bare minimum in a contract. You have to make it very clear what's the nature of the relationship, if you are going to do it for research or for developing a new product, if it's only commercial or not. You should choose your company type. You should make it clear what's the share of each party of the company, what are the parties' contributions, and by party contributions, especially if your company is providing only technology and not any financial contribution, then you should make a valuation, economic valuation of your technology that you are providing. You have to make it very clear. If knowledge is what you have, but not money, well, give it a number to that knowledge and put it in the contracts. Of course, the most important part that companies never forget is to include what are the profits, but also you should include who's going to pay the taxes, who's going to pay the fees. If you're going to develop a new patent, who's going to pay for that, who's going to pay for the annual fees, who's going to be in charge of enforcing if there is a patent infringement. Everything should be kept or should be clear from the very beginning. What I always advise is to include a method of control, especially these days, that companies cannot send representatives to China. It's always when that the EU party should be able to control what is happening, what is being done, what are the type of developments that are being created, but also include a mechanism of decision making. If there is some incident or something that was not foreseen at the very beginning, and we have to make a decision, how are we going to make a decision? How are we going to vote? Who will make it? What happens in a case of an emergency? Make it clear. Especially in the case of new improvements, and especially in the case of the scenario in which you are developing a new product, but during the development process, you realize that you have the opportunity of came up with a new improvement, a new patent, a new product that you didn't foresee at the very beginning. If we have to readapt our strategy, we have a new opportunity. How are we going to deal with it? How are we going to discuss it? Who's going to own it? Do we have to invest more money? How the money will be invested, etc., etc., etc. By this, I mean to create a mechanism in which these new opportunities, these new improvements can be discussed. Eventually, you can have a second contract to deal with this particular situation. But at least give it a chance in the very beginning about how to canalize this and how to go as fast as possible to the new stage of negotiation and organize it and make it clear. Regarding licenses, there's the one that we have two slides on that. The topics that you see on the screen are also the relevant ones. If you are providing license, you're providing it for a territory. You have to be careful about controlling the parallel exportations. If you are providing non-exclusive licenses, you should limit it in time, the duration. You should include or limit the context, the content, sorry, what are exactly what you are providing. You are providing a patent, but are you providing also the trademark? Are you giving also trade secret know-how? The clause that no one forgets about is royalties, that I never have to highlight, always paying attention to that one. But what you should do is to, again, include a clause about how to control, especially if you are providing a license to manufacture certain products, to control quality, to control quantity, to control export, sales, etc. Now it's more difficult because, again, pandemic, you cannot come to the country and actually control it. It's harder, but you can also send a third party to do this control. You have to you need to include the method in which you control. Also, you should include a conflict resolution method in case there is any dispute. You should include clauses about what's going to be the jurisdiction in case you have to litigate, and clauses about damages, return of documentations, etc. What is important for licenses is that you also establish limits and ways of having more control on what can be done with your license. For example, by this I mean, if you're providing a license about manufacture of a product, but you don't want the other company to start studying that product because they will learn about it, they will have to manufacture it, they will know how to do it, but they can improve it. Then what you should do is to establish a clause, so to include a clause in which if there is any improvement, if there is any update, that you will be the first one in order to receive a license over that improvement, that you will participate, that you can collaborate, that you can be also owner of that improvement. Because what you don't want, if you are just providing a license, is to creating a new competitor. What you want is to keep control, especially if you are the technology leader, to keep control of that leadership. And again, the last important clause that you have to include is confidentiality, so they don't disclose those secrets that you are providing them. Regarding, and finally, how we are with that? Yeah, okay. The enforcement and how you can react efficiently. If you spot an enforcement, the first thing that you should do, besides looking for a lawyer, is to collect evidence. You will be able to be compensated, and you will be able to win as long as you can prove what you have to show. So the first step is not being desperate, but collect evidence. Here there are different types of methods of collecting evidence. Normally, it's with notaries, the most efficient way, but also if the infringement is happening online, you can take advantage of technology. You can use blockchain for obtaining evidence. You can even take advantage if you see that you are providing a license to a manufacturer and the manufacturer is selling products in a different quality and sell them in e-commerce. You can take advantage of the e-commerce platforms because they have programs for binding samples in a way that the entire purchase is done in a very specific channel in which everything is controlled by notaries and everything is registered and can be used as evidence. Find the way of going to the jurisdiction that is most convenient for you. If you had an agreement and you included an arbitration clause, then maybe you end up in the jurisdiction. But if you haven't, or you decide that it's better going directly with the court, you can go to the regular commercial courts. You can go with even criminal court if it is the case, or internet courts. Normally, what I would advise you is to go with the IP courts because they have a better understanding of intellectual property rights. And yeah, so they can deal better with more complex cases. Remember that what you want to do is you have to decide what you want to achieve, how money you want to spend, how many infringers you have. Those questions that you see on the screen, they're going to help you to decide exactly to which type of court go. This, of course, should be decided with the advice of a local law firm. So finally, some takeaway messages. Again, as I started with the presentation, register your IP in advance. The soonest that you do the registration, the better. Protect your unregistered inventions with trade secrets. Remember, everything that is not registered it will be protected as long as you manage to keep it as a secret. Combine different types of IP rights to protect your business. Study your potential business partners. Study the law and the bureaucracy of your particular sector, and contact public institutions for a better understanding of the market. By public institutions, it could be, for example, the China IPSME help desk. We normally reply within 3 working days in our helpline. We are free, fast, and confidential. So please, if you can scan our QR code and provide us some feedback about this presentation, that is going to be very useful for us. It's just going to take a few minutes. And with this, we proceed with the Q&A. So I give back the floor to you.
Many thanks, Matthias, for your very detailed explanation. You introduced the basics of technology transfer, not only the definition, but also the ways technology is transferred, the types of technologies, and rules for technology transfer in China. Apart from the foreign investment law, there's some new laws, new rules. And also you talked about the point to be careful about, such as to avoid bureaucracy from stealing your IP, to study your Chinese business partner, to protect your invention with trade secrets, and also the measures of protection. And you mentioned that it is very important to always keep an original copy of contract in Chinese when transferring technology. That's, I think, the top priority when signing a contract, when transferring technology in China. And that would help in case of disputes. Yeah. And you also raised the principal clauses of a joint venture, and mentioned the nature of the relationship. In a contract, you need to be clear about the nature of the relationship, the company type, parties' contributions, control issues, confidentiality, and in case of infringement, how to react efficiently. We understand very well your presentation. Many thanks, and I will give the floor to the audience who may have some questions. You can text your questions in the chat box, and also here offline we have some participants. If you have any questions to Matthias. Okay. I have a question for you.
Yes.
Okay. How to know if my trade secrets are sufficiently protected?
Well, it's not an easy topic because, as I mentioned, there is no mathematical rule. It's not that you can grab the law, read it, and say, okay, if I have to use encrypted information, I have to have NDA, and I have to have a stamp on any document. It's not so easy. What is important is to know that the criteria that the anti-fair competition law does is to, or request you, is to use a reasonable amount of protections. But reasonable, that means that the resources that you have to invest on the protection should be in line with the profits that you expect and the importance of your technology for your own business. So those protections that are, let's say, cheaper to apply, which, for example, could be the use of encrypted information, to have an antivirus in your server, to use a stamp on the document, to have an NDA agreement, those are kind of mandatory regardless the type of technology that you have or how important the security is. Because again, those are easy to apply and they're cheap. Then with more complex and more sophisticated type of protection, for example, that you need to transfer a prototype from one country to another one and absolutely secret, well, that's only for those scenarios in which the prototype has actually a lot of value and is going to be extremely critical for your company, or you know that someone will try to steal it.
Thanks for your detailed reply. We have 2 more questions here. how to protect technology transfer made through consultancy?
Well, it's a difficult topic because when you are doing consultancy, you are actually providing knowledge. That by definition, consultancy is that. So what you can do is to control the amount of knowledge that you are providing in such a way that you let the company know exactly what they need, but no, you don't provide everything that you know. But this is very common, for example, for those companies that instead of consultancy, what they offer is service. For example, a company, it's very common that a company sells a machine, a device, and if there is any problem and it needs to be fixed, well, they will just send a representative to fix that machine, but they will not let you know how to fix it, so you don't know how it works. If that's possible, if you can apply this type of measures, well, that's something you should do. But it's purely consultancy in which you are providing knowledge, well, it's difficult to control or to protect technology transfer. I mean, you will be in 100% of control of what you are telling, what you are saying.
Thanks. Next question. How about subcontracting part of your research to China? For instance, research on a chemical compound or clinical trials. What should I pay particular attention to?
Well, when just contracting a research, what you have in mind is a purpose, that you want to obtain a final product or a final solution. What many companies do when they subcontract is that they actually have several subcontractors. Oops, I close it. In order to not let them know the entire process. They don't know exactly what's the purpose or the final use, and they don't know how to achieve the final version of your commercial product or your. What they do is to split it in such a way in which you are the only one that have full control of the research. Of course, that depends on the type of technology, if this is possible to be done or not. At the end of the day, what you should try to pay attention to is that you have the ownership over the final or the aspect that will be protected with the patent. It could be technology, it could be a product, it could be a process. So when interacting with these subcontractors, you should have clear clauses that makes very, very clear that you are going to be the owner of that result. Now, if they reach a result and that result can be patented, can be registered, you will be the one in charge of doing the registration and it will belong to you. Due to the Chinese laws, you will have to, of course, compensate and provide or to pay for those services. The law specifically says that the compensation and the payment should be reasonable again with the profits that are expected from that final result. It says that it should be reasonable. So you have to be careful about this aspect, but you can make it clear that you are the one that is going to own that technology.
Okay. Maybe we have one last question.
There was someone raising their hand. I don't know if already wrote the question or not. Okay, then proceed with.
I'll ask this question.
Yeah,
if there's more question.
There's more time. They can write it.
Should I use NDA, non-disclosure agreement templates, or should I design my own NDA?
Well, none of them. Actually, I don't advise you to use the templates because NDAs should be used or should be made tailor-made. So it pays attention to all the characteristics of your particular case. To design your own NDA, it's not advisable except if you are a Chinese lawyer. My advice is always to go with a local expert that will know exactly how to enforce it. So when making the NDA, will include all those particular clauses and all those rules and details that are important when you try to enforce it. At the end of the day, if you're signing a contract and you want to be compensated, you have to make it workable with the Chinese court. So the best scenario is going with the Chinese lawyer who will finally litigate under your name and say, please do this and make it efficient.
Yeah.
May I have contact information and send question by email? Of course. Can we open the slide?
Yeah, sure.
I can copy the share screen. There. No, not yes.
Yes.
No. No, that's the
Can you see the?
that's the folder. No. You open the folder, but not the. That one.
Can you see the QR code?
No.
She needs to.
Question box.
Yeah.
On the right side.
She needs to copy.
Left side.
I think she can see.
Slide. On slide, right. The chat.
There we go.
And you can always, we will distribute the PPT slides.
That's for sure, yeah.
To our
Worst case scenario, you can Google us and reach us by the website, yeah. Or buy to us.
Or you can visit us.
Yeah, you can visit our website.
Where from?
Me? From Argentina.
From where?
IPSME.
From
the country or?
Country.
Argentina.
Argentina. Ah.
Do you have any specific questions on today's meeting?
And the more transfer the technology and focus for the finance evaluation. But sometimes never regarded about the social event. For example, and in this time, the China transfer a lot of the new technology into mainland. However, the China pollution increased very quickly, especially for the ozone. Although the concentration condense the increased very fast. Not only the China, also the Northeast Asia, the China, Japan, and South Korea, they increased very fast. Sometimes from statistics, that these three countries, that COVID-19 also increased very fast, especially for the North Korea and South Korea. If there have the comparison, North Korea there's zero diagnosis, but the South Korea, then nearly about 520,000 people that have the disease. If we also think about the software, maybe the technology transfer, maybe they're more useful for the society.
It is true that sharing technology has an impact, social impact. And there are certain technologies that the authorities, national and international, they did agree that they should be facilitated and they should be shared. There was a huge debate at the beginning of the pandemic about patents towards the vaccine. They should be patented or should be available to manufacturers. However, this topic is rather complex because intellectual property rights in general, they work very well as an incentive for innovation. Companies, they innovate because they expect to have profits, and they have profits because they can have intellectual property rights. And if you remove this incentive, you remove the reasons why they should invest in those technologies. So the topic is actually extremely the social impact of intellectual property rights and how much they should be enforced or not. And but it's a very complex debate. There are positions for defending every aspect. Yeah, technology transfer is involved in that. If they should be available or even freely or not. Yeah.
More questions?
In case of know-how technology, how do I protect my rights on the know-how technology?
How do you protect your know-how? Well, from the very beginning, what you have is something that your competitors don't know. That's why it's what you have. There is a rule that you can apply that is called the need to know rule. This means that you only give that information to other person as long as that person needs that information for doing its job. So, for example, if you are a company and you need to fix a machine, you send your technician. Your technician needs to know how to fix that machine. So you have to provide this knowledge. But those other people that are not going to fix the machine, they don't need to know specifically about how to do that. So you don't give them access to that information. That rule, even though it seems to be a little bit simple, it's a good criteria to how to distinguish who you give access to or who you restrict to having access to that information. At the end of the day, it's very hard to give a general final rule that works well for every scenario. It's really case by case. But I think the need to know rule is more or less the best criteria you can apply.
Encourage of know-how technology. How do you compare the benefit of having a license of patent or invention and the know-how?
Well, when you provide a license, you provide a license over an already registered intellectual property right. If it is registered, it means that it's available on the public databases. For example, a patent, you can just look for it, have access, read it, and learn for it. In fact, patents databases are a very good source of information for scientists. So when we talk about know-how, it's that knowledge that is not present on the patent. So you cannot have access to them by going to a public database. You need to get in touch with the person, the people who know that. That's the main difference. Regarding how to protect them, it's there. You protect your know-how as long as you don't disclose it. But your patent, it's already protected if it is registered. It's there. You only need to keep paying the annual fees and enforce it if you see an infringement. But it's available but protected. The other ones you should always be careful and always be doing the
Which
effort.
way of the license or know-how you encourage for the scientists to adopt?
Well, for scientists, it's quite difficult. Or this, how to deal with scientists, sometimes it's difficult because scientists are, in general, yes, scientists or investors, in general, not always, but in general, they are they want to publish. They belong to the world of academics and they want to publish. They're looking for not only this financial rewards, but they also want this academical fame, reputation. So what the company can do to keep this under control is to establish clear rules for their own employees. A scientist, at the end of the day, is an employee of the company. So you can use this handbook for employees of your company in which you establish rules, you create protocols on if they are working, what do they have to do, what confidential measures they have to apply, what can they publish. If a very simple rule you can apply is if you want to publish something, present it first, get the approval of the company, and then you can publish it. So you control. If not, you will have to compensate. These are rules that you can easily apply. Then in practice, I understand that the damages that the companies can suffer for a disclosure of technology, it's difficult that a single person can pay for all those damages. But that is a problem of practice. It's difficult to resolve from the legal point of view. Yeah. You're welcome.
Thanks, Matthias, for your clarification, and we are running out of time. And thanks everyone for your participation. If you have any questions, you can send directly to my email or send to the China SME help desk. We already showed the QR code, and we are very happy to share our knowledge and to help European SMEs to better protect their IP in China. Okay. And not only SMEs, but also big companies.
Yes.
Yeah.
Of course.
Are you
Thank you.
making or?
Yeah, I'm making it.
May I have your